and I would like to welcome members and guests to the 14th meeting of the 2019 Standards, Procedures and Public Appointments Committee. Agenda item 1 is to take business in private. Our first item today is for the committee to agree to take its approach to the Scottish Elections Reform Bill in private at a future meeting. The members agree to take this in private at a future meeting. Agreed. Thank you. Okay. Our next item is agenda item 2. It's the Scottish Elections Franchise and Representation Bill. And joining us today are Professor Anthony Duff, member of the Howard League Scotland Committee. Thank you. Michael Clancy, Director of Law Reform at the Law Society of Scotland. Thank you. Thomas Halpin, Chief Executive of SACRO. And Cathy Asante, Legal Officer of the Scottish Human Rights Commission. Thank you. Okay, so what I'm going to do is give each of the guests a couple of minutes, if you don't mind. If you don't need to take it, but just to give yourself a wee preamble about your position, and then we can start taking questions from the members, if that's okay. So, Cathy, would you like to say anything at all as an intro?
Yes, thank you for that, and thank you for inviting us to give evidence. I suppose in the simplest sense, this can be looked at as a need to ensure compliance with Article 3, Protocol 1 of the European Convention on Human Rights, which is an issue that's been outstanding since 2004. And I don't think there's any doubt that the law needs to be amended to give some prisoners the right to vote in order to ensure compliance with the European Convention. So the question really, I think, is about how far to go in terms of providing that right to vote. And the European Court hasn't prescribed exactly how that should be done. It does leave a wide margin of appreciation, which means that it's really the job of national legislatures to decide what's the most appropriate thing for the national context. So, coming from our role where our statutory mandate is to protect and promote human rights, the approach that we have taken in looking at this bill is to think about what human rights standards say about whether prisoners should be given the right to vote and the guiding principles that can be used in order to determine how that should be done. So looking to both what the European Court has said about the matter and to international standards at the UN level, it is possible to discern some guiding principles that can be used to inform this debate. The first is about the purpose of imprisonment and how that fits with prisoners' human rights. The second is a principle of maximum suffrage. And the third is a need for proportionate rational reasons if the right to vote is going to be restricted, and what that says about what the bill is putting forward today. So on the question of the purpose of imprisonment, it's very clear that in terms of prisoners' human rights, the deprivation of liberty that comes with imprisonment is the punishment. And other human rights will be impacted upon that necessarily in terms of people's right to family life, for example, their right to autonomy. But there shouldn't be additional restrictions where that is not necessary. So that comes to the question of whether the right to vote is one that actually needs to be restricted alongside imprisonment. It's also clear from looking at the human rights framework that the purpose of imprisonment is primarily about rehabilitation and less about punishment. Secondly, the European Court has been clear that the starting point is a presumption in favour of maximum suffrage. So we should be looking at why people, the starting point is that everybody should be allowed to vote and only excluding that where there are rational reasons to do so. So in that sense, what we need to do is look for what is the actual aim behind excluding prisoners from being able to vote. And then what is the most proportionate way of deciding how to do that if it is going to be done. In terms of the legitimate aim that's before us at the moment, it's being put forward as the aim of preventing crime, that it would act as a deterrent to crime if prisoners know that they're going to lose their right to vote. And we really have some questions about whether that is a rational aim and that removing the right to vote is actually effectively acts as a deterrent. In terms of the way that you might go about restricting the right to vote, the proposal is to determine that by the length of sentence of 12 months. And I I think the question there is really about whether that is the most proportionate way of doing that. Certainly we can look at some international comparators that have greater proportionality in terms of identifying which prisoners should and should not be allowed to vote. For example, judges being able to decide on sentencing, or identifying offences that actually have some connection with the exercise of the electoral system. Overall, we see this as an opportunity not just to ensure compliance with the European Convention, not just to do this because we need to tick off something that the European Court has decided needs to be remedied, but to actually look at the situation anew and come up with a principled stance as to prisoner voting. And if the Scottish Government and Parliament wants to show human rights leadership, then we think that the best way to do that is to look at these human rights standards and principles and use them to inform the debate about what should be done here.
Thank you very much. Thank you very much, Cathy Asante. Michael Clancy, would you like to give us a preamble, please?
Just shortly, Convener. Thank you very much. We at the Law Society come at this bill from a different angle from the Scottish Human Rights Commission, principally because the bill is quite an important bill. It covers lots of areas of enfranchisement and relates to the competence of the Parliament to legislate. And of course, as you know, in the Scotland Act 2016, responsibility for elections in Scotland was devolved to the Scottish Parliament, and this is the first orderly opportunity for legislation to be made in connection with those additional powers. And that is where we think that there is an issue around and about questions relating to prisoner voting in particular, but it spreads out across the bill in terms of the competence of the Parliament to enact legislation here. And we have no doubt at all that the Parliament has the competence to do what it is being asked to do by the government in this legislation. That's important because of the provisions of the Scotland Act 98 relating to the general competence of the Parliament, and under Section 29, if the Parliament enacts legislation which is not within its competence, that legislation is not law, particularly if it contravenes or is not in compliance with the European Convention on Human Rights. Having the capacity to legislate on elections means that the crunch point of compliance with ECHR comes into sharp relief, and that is something which Cathy has identified in terms of the way in which that affects prisoner voting and compliance with that trail of court decisions from Hurst in 2005 to the present day, and the way in which other jurisdictions within the United Kingdom have approached this. And of course, up until devolution, we were bound by the approach which the UK Parliament and UK Government took towards the extension of the enfranchisement to prisoners. So that's where we come from. Happy to take questions further along the road. Thank you very much.
Thank you, Michael. Thank you very much. Professor Anthony Duff of the Howard League Scotland, please.
Yes, thank you, Convener. And we agree strongly that it's important to go beyond the minimum requirements of the Human Rights Convention. So we see this bill as an important first step, but only a first step towards what we would like to see a far more ambitious aim of giving all prisoners the right to vote. And the central issue, we think the central issue is one of citizenship. Do we see those in prison as citizens still, who are still members of the polity, who have a right to engage in its affairs, or do we see them as outsiders who have no part to play? And we feel strongly, for reasons both of democratic recognition and rehabilitation, they should be seen and understood and treated as citizens still. They're in prison, they're being punished, but still they are members of the polity, and they should have the right to vote in its elections and vote for their own fellows' future. So we'd like to see, in the end, the right to vote being extended to all prisoners, not just to those serving less than 12 months. A second point I'd like to make briefly concerns practicalities. It's important that the right to vote is more than just a formal right which isn't really used. It matters that they be able to use the right to vote, and that means they need to be assisted, encouraged to use that right. And that involves resources of various kinds to make sure it's possible to use it and to get the information they need to engage in the debates they need to engage in to use the right to vote fruitfully. And of course, the SPS is under heavy pressure all the time. So if the right to vote is extended, if it's to be a serious right, then we need resources to make it practicable for the SPS.
Thank you very much, Anthony. And can we have Thomas Halpin, please? Thank you.
Thank you very much, and thank you for the opportunity to present to you. I suppose the position that I want to outline at the start is not the facts in terms of the legislation, etc., that my colleagues are already touching on. It's about the people that it impacts upon. Largely, this is a group who have been excluded and have been deprived throughout their life in all sorts of circumstances. I'm sure members will understand that. And the decisions that are being made around them are very much driven by emotion and values base of others, etc., and very often who haven't experienced those same experiences. It's about making sure this is proportionate and fair, but also rational. And if we look at the progressive approach from the Parliament in recent years around presumption against short sentences, etc. And the chance that some people, there are loads of examples where people have been convicted of the same crime, maybe at different diets, they've been sentenced differently, and one is excluded and one is not, just by the randomness of that. You then look at those people who are in prison for a long time for very much more serious crimes, and the emotional argument comes in about excluding them. Civic death has been used often to describe that. And for me, actually, if you take a really rational look at that, these are people who still have a stake in society. They have families outside that they may be impacted upon in the education system, for instance. They would have a right of to have an interest in children or spouses, etc. And there are examples there of people who have been absolutely written off. I mean, in newspapers up and down the country, in the UK, there are columnists who have been long-term prisoners who are out and playing a very meaningful part into society, and they would have naturally, in that rational discussion where it was at that time, been written off as civic death and not worthy of this, but there they are out there. So my please don't fudge this. It's a human right, and it's if we are wanting an inclusive Scotland, we should provide the right to vote to all prisoners.
Thank you very much, Thomas Halpin. Okay, can we, the guests are all intimated that they're ready to answer questions. Can we possibly start off with Gil Patterson, MSP, please?
Yeah, thanks very much. I want to ask a general question that might assist the general public, this question, and it's a Brexit question. And since if this bill has been driven by the European Court on Human Rights, and we have if we come out of Europe, what effect would this have if we implemented this bill? Is there a likelihood or a possibility that either the Scottish Government or the UK Government could default back to taking that right away from prisoners?
I'm happy to answer that question.
Yeah.
Thank you. I think it is really important to clarify that, just for public understanding in particular, because the European Union is completely separate from the Council of Europe, under which the European Convention sits. So we're actually dealing with two separate European systems here. So when we come out of, or if we come out of the European Union under Brexit, that wouldn't have any automatic impact on our membership of the Council of Europe, which means that we will remain signed up to the European Convention. It remains embedded in our law through the Human Rights Act and the Scotland Act. So there's no automatic correlation between those things. There have been debates about changing the Human Rights Act or our membership of the Council of Europe, but those are really separate debates, and there's no current plans on the table to change that legal position at the moment.
Okay.
That's correct. I mean, for Brexit purposes, leaving the European Union would have no effect on our membership of the Council of Europe. But of course, as you know, there has been a long, grumbling debate about the relationship between the United Kingdom and the European Convention on Human Rights, which may, at some point in the future, crystallise with our government deciding what it wants to do about membership of the Council of Europe and the European Convention on Human Rights. Now, I say that with one proviso about the crossover points in connection with the European Union, because the Charter of Fundamental Rights of the European Union contains certain provisions which are relevant to this debate, but only in connection with matters relating to the European Union. Therefore, things like the restrictions on being capable of voting in a European election or something like that. And this was helpfully litigated on in the case of Delvin, Thierry Delvin versus the Commune de l'Esparre-Médoc and the Préfet de la Gironde a few years ago in 2005. And in that case, the European Court of Justice ruled that French law, which deprived certain convicted persons of the vote, was not an unlawful breach of the right of European citizens to vote in elections for the European Parliament. So there is a crossover, but I would like to advance the idea that we may have experienced the last vote for the European Parliament, which this country will have in the meantime, and therefore it might not crop up again. But I don't need to tell you that that's a highly contentious area, and it probably is not up to me to pontificate too much on it.
Okay, thank you. Gil, would you like to pontificate a wee bit on it?
Well, it just raises one question in my mind, is would it, if a UK government who had decided that they do and would and put forward legislation to take us out of the jurisdiction of the European Court and the human rights itself, would Scots law still stand, or so would Scottish law need to be changed also, or is there an overarching in the explanation that you gave?
May I ask, when you use the phrase European Court, which European Court are you referring to? The European Court of Human Rights? Or
yes.
Well,
Yes.
if a future government withdrew the UK from the Council of Europe, then the court would not have jurisdiction over the UK. Or if a future UK government repealed the Human Rights Act of 1998, then the domestic litigation in connection with the convention would not apply. So that those two are possible outcomes of an approach to human rights which a future government may take on. Beyond that, we're into the realms of significant speculation.
Yeah, and just before you go on, Gil, Professor Duff, would you have something to add?
Yes, I think it'd be trained to focus only on compliance with the Convention on Human Rights, and that's a minimum requirement we need to meet. Now, here's a chance to think beyond that and think for ourselves how we should treat prisoners in terms of voting, and whether we should do rather more than is required minimally by the Convention. And that's why Howard E. Scotland wants to say we should go beyond that and think about enfranchising all prisoners, not because that secures compliance with the requirements of the Convention. It goes beyond that to think for ourselves, how should we see these people and how should we treat them? So I wouldn't want to focus only on what is required to comply with the Human Rights Convention.
Yeah, thank you. Gil?
Yeah, thanks so much. I am going to develop a question in that very point. So, but if I could ask you what your view is on the approach taken in the bill whereby the right to vote is linked to the length of sentence.
Yes, Thomas Halpin first, please.
Thank you. I explored that in my opening statement, separately from the legislation about whether it's right or wrong to exclude people. And we would expect parliamentarians and lawmakers to have a rational view, a mature view, and one that's for the good of all communities. And the exclusion of people, you can make the arguments one way and you can make it another way. But the fundamental thing here is about people being part of a positive and thriving society in Scotland. And other than a very, very small number, even those on long sentences will still return to communities one day and have a stake there. And the reality is the reason to deny them that vote at this time is one of punishment. It's not one of risk. It's not one of threat to wider communities. It's a value-based judgment. Now, we want to see people have a reason to rejoin positively the communities to which they will return.
Before you go on, Gil, Neil, is
It's kind of fundamental. It's a bit linked to this, but it's more fundamental. How are the public protected or prisoners rehabilitated by the removal of the right to vote? Does anybody believe they are?
There's a lot of shaking of heads going on. Cathy, would you?
I'm not raising my hand because I do believe that they are. I've struggled to see what the connection is, why this particular right is one that has an impact upon victims, upon deterrence of crime. The rational connection seems to me to be quite confusing. And conversely, allowing prisoners to vote would seem to have rational reasons that would contribute towards rehabilitation in terms of enhancing civic participation, in terms of inclusion, maintaining their connections with their community and their investment in society. That all appears to me to stand up to much more rigour than the argument that it deters crime.
I can see Professor Duff wants to go on. Neil, do you have a wee follow-up?
Just to add to that, in terms of any research that's been done or your experience of working with people in prisons, have you ever heard of any offender who said something along the lines of, "Yes, I was going to ram raid the bank and steal the money, but I realised that I wouldn't be able to vote for Bill Kidd or Neil Findlay, so I didn't bother."
Right. Anyone with that knowledge? No. Right.
No.
Professor Duff.
I think that makes, if you just think of the standard aims of punishment might be thought to have: retribution, deterrence, incapacitation, rehabilitation, and ask if the losing the right to vote serves any of those aims. It's hard to see how it does. It doesn't seem apt for retribution. It doesn't deter. We believe that. It doesn't help to incapacitate. And if anything, works against rehabilitation, because having the right to vote does help to rehabilitate. So, of all the standard aims of punishment, losing the right to vote doesn't serve any of them and works against at least one of them.
And Mark, you were...
Are there any examples where you think a civic death would be appropriate? I'm thinking of examples where somebody has committed a crime, against democratic institutions, or has been part of a democratic institution themselves and shown, gross criminality and misconduct. Again, I guess it's kind of shifting the issue around, risk to the public. I mean, these aren't people who are standing for election, but they are voting in elections. So that's one example. I wonder if there are any others where you think there's a proportionate reason why civic death may be appropriate.
I think that's the best case. The question is how we see the right to vote. And compare driving. If you're a driver, you can lose the right to drive if you drive badly enough. You lose your license. Because driving is not a basic right. Driving is not quite a privilege, but it's a fungible right. But if you see citizenship as being basic to your identity as a person, the right to vote is then crucial to your civic being. And the argument is that then you shouldn't lose that, even if you misuse it. That might invite monitoring, warning, and so on, but you shouldn't be able to lose it just by even electoral malpractice. Maybe the other case would be, in the extreme, a self-avowed terrorist whose aim is precisely to destroy the political community. That seems a case where you say, well, that person has ruled themselves out from taking part. So maybe that would be a case. But I think even with electoral malpractice, it's important that they preserve the right to vote and be encouraged to use it appropriately.
I suppose in that case it could almost be a restorative element. If somebody valued democracy, was against democracy, but was still given the right to vote.
And that's why it's important that the right be made a real one, so they're encouraged to use it properly. So I think it involves making sure they have the information they need to use it, room for political debate and so on. These seem to be important ways of making the right to vote a genuine rehabilitative measure.
Ken, we have a wee contribution from Michael Clancy, then short intervention Tom Mason, and we're going back to Gil. So Michael, please.
Well, I was never ever present at a conversation in Barlinnie where your name came up, convener, but in any event, or indeed Neil Findlay's, just in case people think that I was making a distinction. I think the point which you make about the issue of civic death being applied to certain types of crime, I mean, we've seen that in legislation in other countries. So, for example, in the case of Scopola v Italy, the court came to the conclusion that someone being excluded from the vote was no violation of A3P1 because under Italian law, only prisoners convicted of certain offences against the state or the judicial system or sentenced to at least 3 years imprisonment lost the right to vote. So you can see the use of offences against the state, offences against the judicial system would be in that kind of category that Mr. Ruskell was talking about. I would contrast that with the situation in Turkey, where the case of Murat Vural v Turkey in 2005, the applicant was convicted under the law on offences committed against Ataturk because he poured paint over statues of Kemal Ataturk. He was given an extraordinary sentence of 23 years, and that also excluded him from voting. Now, there had been a violation of Article 3 in that because it was disproportionate. So it's a question of balance, the margin of appreciation, proportionality. These are the issues that one needs to deal with. And since we have moved off from applying the death penalty in any circumstance, issues relating to civic death don't really apply as they might have done so some time ago.
Mason first, please.
Yes, I'm just trying to get the logic right of all of this. Why is voting specifically separated out against other losses of the rights in terms of imprisonment? I mean, they lose the right to family life, they lose all sorts of things in addition. So, voting is just one of several issues which is lost by imprisonment. I'm just wondering the logic by taking out voting. It could be anything else on a long list of things that they're deprived of if they go into prison.
Yes, Mr. Duff, Professor Duff, sorry.
I think we heard the reply before that imprisonment is essentially loss of liberty. Along with that, inevitably you have other kinds of loss too. If you're imprisoned, you thereby can't maintain ordinary family life. So inevitably there's an impact on family life of being imprisoned. But the right to vote isn't in that way an inevitable loss when you're imprisoned. It can be maintained still. So the basic thought is if you start off with imprisonment as loss of liberty, and that's what you essentially lose, and then ask what other rights must be constrained or can be maintained once you're imprisoned. And that seems to be the way forward. And on from that point of view, the right to vote can survive because it can be maintained even while you're imprisoned.
Yeah, so can many other things can be maintained in prison. I mean, in terms of open prisons, the right to access to newspapers and television and all sorts of things.
And all the rights should be maintained unless there is good reason to do with punishment or incapacitation or deterrence to suspend them. So, yes, we start with the position that every right should be maintained as far as it can be consistently with imprisonment and its purposes.
Alvin, please.
These rights may be curtailed or restricted, but they're not lost when someone is imprisoned. The connection with family is so significant that the Scottish Prison Service has created family centres and visiting centres, but maybe an example, and it's whether it is the right thing to do to withdraw the right to vote. And again, it's this emotional the separation of what is so serious that it was so abhorrent that you would take it away. It's very difficult to make that distinction. You know, there are many people in our prisons who have been convicted of homicide, who have circumstances around that case that actually they're not evil people. They have made a very bad decision in their life, and maybe even wasn't a decision, it's the circumstances, and they are there. So the idea that we can be rational in separating in a judgmental way, I would say is questionable.
Neil Findlay, just very quickly, and then back to Gil Patterson, please.
Just to confirm, prisoners still have the right to stand for election, is that correct? I mean, famously, Bobby Sands stood for election and was elected, and I believe that's not changed. So they have the right to stand, but they don't have the right to vote. Is that seems to be?
I believe that is the case. I believe that is the case. Can I come in on this idea of what is the difference between taking away, in the ordinary course of events, the right to family life and taking away voting? I suspect, haven't studied this in depth, but that there is still a sort of shadow of the franchise being something which is given rather than something which is inherent. And that, I mean, we are celebrating through this year 100 years of women being given the vote. So the franchise is something which is very close to in time to periods when people did not have the vote. And of course, the shift from 21-year-olds to 18-year-olds was even within the lifetime of those who are seated round this table. So I think that unless there's someone who's very, very young, but I think that is what the difference is. Whereas right to family life was always considered to be inherent in a person, and the removal of that right, in a sense, if one committed crime, would mean that was society showing its punishment element, its retributive element towards that individual. But I think that that's where the issue comes about.
And just quick, Cathy.
I think it's difficult to discern how we arrived at this position and how we actually make this connection. And I think it's interesting to look at the other countries across the Council of Europe where the connection is not made. There are, I believe, 21 European countries where there is no ban on prisoners being able to vote. And so there seem to be completely different approaches that arrive at this question in the first place of why we're talking about prisoners and this specific right.
Okay, so, yes, and Michael Clancy, thank you.
One other point on that, I suppose we do not have a written constitution in this country, something which people are quite interested in debating. And the issue of a right to vote might be expected to be part of that concept if it ever comes to any kind of fruition. But there are constitutions of countries who are signatories to the Council of Europe where they exclude the right to vote for prisoners, such as the Russian constitution or until recently, the Ukrainian constitution. So I think we've got to be cautious about just saying that because countries have a constitution which bestows the right to vote, that is necessarily the way that constitutions will always be, and that constitutions can be used to entrench the idea that certain people who are convicted should not have the vote, as well as ensure that they can have the vote.
Very much. And sorry, Gil Patterson, please.
It's another kind of fundamental question, because again, the choice here is to use a 12-month time bar as a definitive time before otherwise don't qualify. And I wondered if that maybe a better measure might be what the crime was, and particularly in relation to women. I was watching a programme on television which was very apt. 2 women that were put in prison for non-payment of the council tax, and the circumstances that got them into that situation was quite emotional, to be quite honest with you. So if, for instance, a woman was stealing to, rather than pay the bill, stealing to feed her family, or stealing to pay the bill because she spent the money feeding herself and her family, rather than is that a crime against society? Or is the fact that we put somebody like that in prison a crime against the society? So the measure that we're using, time rather than what actually took place, have you a view on that, whether it should be something different from what's been suggested in the bill?
Can we have Thomas Halpin first and then Professor Duff? Thank you.
You raise a very important point. My organisation, along with partners, deliver a significant public social partnership in Scotland that supports every woman leaving Scotland's prisons serving a sentence of less than 4 years. There's a figure there. And we provide them with mentoring. So we have extensive knowledge of the individual circumstances across a large cohort of women, and the data is all there in the background. But the personal circumstances relating to offending, etc., are as varied as you can imagine. And for instance, even women, particularly disproportionately, go to prison because of their circumstances. They're just not able to comply with the justice process, the administration of justice. They don't comply with bail and end up in remand, etc., things like that. And of course, the personal circumstances that cause them to get involved in addiction and as you said, for instance, theft and maintaining families around them is disproportionate in women as for men. So actually to separate it out in crime, because a large number of these women are victims. They're victims of domestic abuse. They're victims of deprivation and neglect as children themselves, etc. And so when you start saying this crime takes you into this cohort and that crime takes you into that cohort, it doesn't reflect the reality of life circumstances for these women. And we are turning round to them and saying, not only are we treating you like that as you go through your life experience, we are then going to make you suffer civic death. So I don't think that you can separate just on crime. I don't think you can separate just in sentence. I think it becomes an emotional decision when you start and judgmental. There's a reality here that we want every citizen to be rehabilitated and play a full part in a successful Scotland, and this is a fundamental building block of that.
Right, well, everybody seems to want to come in this, so you've stirred something up. Can we have Professor Duff, then Michael Clancy, then Cathy Asante?
I suppose the 12-month limit was set as an attempt to crudely say, okay, for the more serious crimes you lose the right to vote, for minor crimes you don't. But that is, as Thomas Rain, he has a good way of capturing the distinction between minor and serious crimes, because those in prison for more than 12 months could still, in virtue of their crime or their own circumstances, not be the kind of figure of the hardened career criminal who people have in mind when they talk about losing the right to vote. So I think if we are going to say some should lose the right to vote and some shouldn't, we need to ask carefully what picks out those who should lose the right to vote. Is it the content of their crime? The crime is somehow against the political system? Or is it just the mere fact of being a very serious crime? And if so, then how serious does it need to be before you lose the right to vote? I think there's no clear answer to that question. And that's one reason why we think we should just say they all get the right to vote. But 12 months seems, in a way, a very mean-minded way of allowing someone the right to vote. It lets in a very few prisoners. But you still disenfranchise very many prisoners who, when you look at their actual cases, are not serious core criminals.
So I suppose what I would do is look at the section, and the section in the bill is making amendments to Section 3 of the Representation of the People Act 1983. And that's the nub of the issue, is that the Representation of the People Act 1983 contains a blanket ban. It says, a convicted person during the time that he is detained in a penal institution in pursuance of his sentence is legally incapable of voting at any parliamentary or local election. And that's the basis on which the Hurst case was taken to the European Court of Human Rights. That Mr. Hurst felt that that blanket ban was contravening European Convention on Human Rights, as Cathy has said, the Protocol 1, Article 3. So when the court made its decision in that case, it was talking about the support for universal suffrage, but that the franchise of prisoners may be restricted provided the restriction is proportionate to a legitimate aim. And these aims including the sanctioning of the conduct of convicted prisoners and enhancing civic responsibility and respect for the rule of law. Crucially, the length of the sentence given to the prisoner indicates the seriousness of the offence. So it's that is where we get this this tension between the length of sentence and the seriousness of the offence. I think that that this bill has landed on 12 months. If you remember the consultation which the Scottish Government ran before this in March last year, we were on the cusp of talking about the presumption against short sentences, and that presumption crystallised in the presumption against short periods of imprisonment, Scotland Order 2019, which the Parliament voted on earlier before the summer, or in the summer. So I think that it's that landing point is something which the Parliament has already decided is an indication of short sentences relating to, or rather a presumption in favour against short sentences relates to the seriousness of the offence, and I think that answers the point which you make, Mr. Patterson. But the question is 12 months right? In the consultation, when the Law Society responded to it, we thought that perhaps a landing point of 4 years was more appropriate if we're taking this incremental approach. Clearly, our advice was not heeded.
Cathy.
Yes, I mean, we do think that this length of sentence based on 12 months is appear to be quite a crude way of distinguishing that doesn't take into account an individual's personal circumstances and doesn't allow for that individualised consideration. And an alternative approach that is taken in other countries and that does seem to win favour with the European Court as well is for it to be determined by a judge on sentencing so that they can take into account everything that they know about the circumstances of the case and maintain a link between the measure of depriving someone of the right to vote and what has actually taken place. And that I think it's fair to say is a more proportionate way of going about it than simply having a cut-off point at 12 months.
Thank you. And Maureen, what would you want me to...
Yes, can I just follow up on the short sentences stuff? I mean, we live in a country in Scotland where we have one of the highest prison populations in the world. So we're obviously locking up people more than other countries already. Is a lot of that on short sentences? You know, I'm not just talking about the 12 months. And is there a contradiction between having the short sentencing rule and the proposals in this bill?
Yes, Cathy Asante first, please.
I know the Faculty of Advocates pointed out at one point that, that there may be some contradiction here, and I think you know, it's difficult to say whether that would actually could be the cause of a further human rights case, and that's untested. But there's an arguable question there that enfranchising a smaller and smaller number of people is actually not in the spirit of providing the right to vote. And I think really that points to a need to future-proof this legislation. If we're just going to minimally comply with what is required by the court as of now, then we may have to return to this issue a number of times in the future in order to review it if anything else arises. And a better way of approaching that would be to think about what we actually think is the right reason to be doing this and to determine the measure around that rather than just what we can do in order to get over this legal hurdle for the time being.
Yes, of course, Maureen.
So I'm getting the sense from the panellists that you don't think 12 months is appropriate. Michael, you said you alighted on 4 years. The rest of you think that it should be available to all prisoners, regardless of length of sentence. So we've got 3. And Michael, do you think...
Well, that was how we responded to the consultation. I mean, now that we're dealing with the bill, it's really a question for Parliament to decide what is the best landing point. Clearly, the Scottish Government has taken the view that 12 months is, or less is an area where people should be able to vote, and that more than 12 months is not. I personally don't have the kind of statistics you were looking for about what sort of crimes get what sort of penalties, but I'm sure that the Crown Office or the Prison Service would be able to provide those. On the point of whether judges should be able to add in at the point of sentencing a disenfranchisement, I think that we give our judges rightly so significant discretion in sentencing, but when it comes to civic rights, I think the Lord Justice General has already indicated that the judiciary are not in favour of that addition to their powers, and I think we've got to trust the judges.
Ask why?
You would have to ask the Lord Justice General that.
Just before you come back, Maureen, Anthony Duff, you finished it. Anthony Duff, would you like to say?
It's just to say, I think that ideally we'd like to think that see all prisoners have the right to vote. Failing that, we also think strongly 12 months is much too low a limit. I can see the argument, I don't accept it, that for really serious crimes, crimes which display a kind of contempt for or hostilities towards society, I can see people might say, well, those people shouldn't vote while they're in prison. I think that's wrong, but I can see the argument for that. But that involves really very serious crimes by very serious criminals. And 12 months doesn't begin to capture that kind of crime. So we need to ask more carefully then, what kinds of crime, by what kind of person, are such that the person should lose the right to vote while they're in prison. I'm not sure I get a simple 4-year or 5-year or 6-year cut-off point. You might do it crime by crime, but in a more nuanced way. But so I think on any kind of 12 months seems much too low a level to set.
If you're going crime by crime, you're going back to Michael's point about the judge making a decision, really.
You could say, here's the list of crimes, conviction for which, plus with a sentence of so many years, would lose you the right to vote. You could just list the crimes which would disqualify you. That would be feasible. It's hard to see how you'd in fact do it. It's not clear what the criteria would be, but that would be a way to go, to try and give a slightly more nuanced way of limiting the franchise to prisoners, rather than just saying anything above 12 months and you lose the right to vote.
Neil?
I can't quite understand the logic of the year. It does appear to be a minimal fudge, if you like, rather than a principled position of saying. So I think we would have great difficulty if a minister was sitting in front of us and saying, "Is this your position?" Can you explain why a year is the most relevant? Can somebody, any of you, and help us in trying to understand what the relevance of 12 months is as opposed to 6 months, 24 months? Because I don't understand it at all.
Yes, Tom Halpin, please.
I've been involved in this discussion with the Parliament, the consultation, over some years now, and I used the word fudge in my opening statement, and I strongly believe that this is the equivalent of, we initially had a 3-month presumption against short sentences because people worry about how will it be accepted, and then there wasn't a crime wave because of that. Crime's actually going down, and we're now looking at 12 months, and we're the same here. It's actually about that emotional fear of how will this be received. We've made the arguments. We expect this to be a rational, proportionate judgment by parliamentarians as to what's needed. There is no reason, in my personal view, for 1 year other than the fear of how emotional it will be received.
And Professor Duff.
I thought, I need to check this, I thought one argument was that 12 months is the longest sentence a sheriff can impose in a summary trial. And that's a way of marking out those crimes which are so minor that they wouldn't go to a higher court for sentencing. So 12 months is thought to mark out the line between the clearly non-serious crimes and the more serious crimes. It's still like a very crude way of trying to do that, but I think that might be the one rationale for it.
My view of a serious crime and somebody else's view would be very different.
Yeah.
Okay, thank you. Thank you, Neil. Okay, can we move on just a wee bit then? Tom Mason?
Yes, and just going to expand, some of my questions have been answered. What is the international scene on this? Who's doing what where? And can you distinguish between the franchise to vote and the rights to stand in elections, which are really, we haven't discussed too much or whatever, because there are, I want to know what the international perspective is, and are we out in front here, or are we falling behind, or are we catching up, or what's the situation?
Yes, Santi, please.
Yes, I had a look at some comparators across the Council of Europe, and there really is a wide spectrum. It goes all the way from a total ban to total enfranchisement. But looking at that slightly more broken down, we have 21 European countries that don't restrict the right of prisoners to vote at all. Included in that is Ireland, Finland, Denmark, Norway, Switzerland, and more. Interestingly, I think in Ireland, the law was changed in response to the Hearst ruling, and they enfranchised all prisoners in 2006, and there wasn't actually a great deal of controversy around that. It passed without a great deal of public or media concern. And then we have 18 European countries that allow some prisoners to vote, and then there's all sorts of different ways that they go about determining that. But in France, judges are allowed to determine whether the right to vote should be removed, and there's a sort of mandatory removal for very serious crimes. But even then, a judge can choose to disapply it. Germany only bans those whose crimes target the integrity of the state, so terrorist crimes in particular. And then the list of countries that has a total ban is much shorter. There's only 8 countries, and that's countries including Russia, Armenia, Hungary. So we can see that there are some restrictions on the right to vote in other countries in Europe, but a lot of those also appear to be much more tailored and more proportionate than a simple length of time cut off.
What about across in America and South America and places like that?
I haven't looked at South America, I'm afraid I don't know. In America, I think it varies on a state-by-state basis, and some prisoners are not allowed to vote. Felons are not allowed to vote for the rest of their lives, even after they've come out of prison. So that's quite at the other end of the spectrum. And then I believe in Australia, some states allow prisoners to vote, and that's in the context of laws which actually mean that voting is mandatory, that everybody has to vote. So they would actually be required to vote in those circumstances.
At the risk of intruding upon the incipient US election, Bernie Sanders is currently going round the stump saying that he would like all prisoners to be able to vote, but currently only 2 states allow that, Maine and Vermont. Other states have varying degrees across the 50. In Australia, there is, as Cathy has said, a distinction between the federal level and the state level. State level is about 3 years, I think, and federal level is 5 year up to 5 years. You can vote if you're sentenced up to 5 years. And looking close to home, of course, in England and Wales, the total ban was modified with an agreement between the UK government and the Council of Ministers so that those on temporary licence would be able to vote, and that the Council of Ministers indicated its contentment with that agreement in December of 2018. I think, and then of course in Wales, there is an ongoing debate and consultation around the issue of prisoner voting, which I believe has not reached any firm conclusion.
Yes.
And what about standing for election?
I don't have any information about standing for election elements.
Okay.
That's something that we can look into and bring back to you then. Thank you.
Yeah.
Thanks for that, Tom.
I mean, the whole issue of standing opens up a whole spectrum.
It does, right, yeah, quite right. Thank you. Now, Maureen, I think a few of your questions about 12 months have been covered. Are you?
I haven't got anything else.
You're
I think
okay
we
at the
can move
moment.
on to administration.
Thank you very much. And Mark, you got some?
Yeah, thanks. Can I ask about the evidence around rehabilitation, but also then about the subsequent reintegration back into communities? Has this been studied? are there particular examples that you can give from the UK or abroad where this has been beneficial?
Thomas Halpin.
There are a number of studies, including a publication by the Scottish Government's analytical services, about what works in rehabilitation, reducing reoffending. And what we know is that it's not possible to give the actual causation, but the correlations around the protective factors that help someone on their journey to desistance from committing offences. And that's complex, and it's around multiple needs that people have around housing, family, motivation, health, addictions. You can imagine all of that. So this sense of belonging to is extremely important in supporting those protective factors and someone moving into rehabilitation. So there is no doubt in my mind that the evidence around the importance of this in terms of supporting rehabilitation is made in a number of evaluations and studies over a long period of time.
Just before you come back in, Mark, just to point out that we're maybe going to run a wee bit further than we thought we would in time, because we've got a lot of really good responses coming in here that's going to help us a lot in our deliberations. But if anyone, we're going to well beyond 11 by the looks of it, so if anyone needs to go, you're perfectly free to do so, because we're not locking anybody up in here. So just Mark, if you'd like to come back.
I mean, you know, to hear what you say that in terms of the general approach to rehabilitation, but I'm thinking specifically in terms of, you know, this participation in democracy, in wider society. I mean, is there evidence specifically around that? And I'm even thinking about, you know, those who are maybe being withheld under terrorist offences, part of their reintegration back into society, their rehabilitation, how this kind of fits with that.
Professor Duff.
Just because we have the blanket ban still in Britain, we couldn't find evidence of the right to vote helping to rehabilitate, at least in this country. I don't know of evidence from elsewhere, because I'm a philosopher rather than an empirical scientist, so I theorise rather than investigate empirically. But if you think about it, anyway, imprisonment is bound to cut various ties you have with your community. It cuts you off from it in various ways. Rehabilitation involves trying to maintain such ties as you can and trying to build up ties again as you're released. And one such tie is a connection to the political life of your community. So insofar as we can maintain that tie, which includes the right to vote, but also includes the right to take part in debates, the right to engage politically, then that surely, it certainly can't hinder rehabilitation. And one way in which you can try to maintain the person's ties with their community. So it seems, as a matter of common sense rather than empirical evidence, that must be the way to go if you're interested in rehabilitation seriously. Because this is one way to maintain important connections with the life of the community to which they belong.
Is there any international examples then of where there's a limited extension of the franchise or a full extension of the franchise of where there's been positive evidence of people reintegrating, maybe even becoming politically active themselves or involved, you know, once they've been reintegrated back into wider civic society, participation, confidence building, all these kind of things?
Tom Halpin, please.
I suspect there won't be many. It's an area that lends itself, it would be a good study, obviously, as you pick it up. But there are loads of examples of people who have entered into political life after imprisonment, including political prisoners, for instance. But one of the experiences that we have, which is really, really positive, is peers mentoring prisoners in prison and out of prison. And there's an example of people who are moving into active citizenship. Now, those are individuals who are definitely motivated within the prison system.
And Professor Duff, did you?
Yeah, I don't know. I could try to find out if there is any international research on this and get back to you on that.
Okay. Thank you. Okay. Thank you, Mark. Now we're basically going to our final round. Voter education and political engagement. And Maureen Watt, please.
Is there any evidence that if prisoners get the right to vote, that they will, in fact, use it? And what's been the situation in other countries, for example?
Cathy Asante.
The only one that I'm aware of is in Ireland, and I believe that the finding was that prisoners voted in about the same proportion as the general population.
Thank you.
Anybody else?
And Professor Duff.
I much would depend on how the right was introduced and how it was treated. So if they're just told you could vote formally and that's all there is to it, then I think plausibly there'd be rather low uptake. If there was a genuine campaign to encourage them to vote, to show them how they can vote, to help them engage with the political debate, then I think you would find a rather higher rate of uptake with beneficial effects beyond that. A lot would depend on the resourcing and how it's organised.
Can I just, thank you. Can I just ask Tom Halpin, because you were talking there about peer mentoring, etc. Do you think that has encouraged more people to do as Miss Watts to me?
There is absolutely no doubt in my mind that that has encouraged people to be active in positive, purposeful activity within the prison system. So I think that one would follow the other. It would be about whether the way it was introduced made it difficult for people to vote, etc. But there is the experience of peer mentoring, the experience within the prison system would definitely suggest that this would be a hot topic amongst that population group in there, in a positive sense of having something that's purposeful.
Prisoners have the choice of where they register to vote. Would it be where they lived prior to going into prison, or would it be in the ward or in the constituency where the prison is?
And sorry, Professor Duff, please.
As I know, the bill proposes that where there is a place they can say they live, they should vote there, they should register there. Where there's no such place, then they would vote in the prison. And actually he's right. So if the aim is to maintain personal connections with their community, then they should, if possible, vote where their home is, where there is a home they've got, to which they will return after prison, then that's where they should be voting. If they've got no home, then by default they'd have to vote where the prison is, and that seems right.
Maureen?
And in terms of the candidates standing for election, how can they interact with the prisoners?
Yep. Well, there's a bit of guesswork there, but Professor Duff.
If the prisoners register to vote in their home, then of course they can't attend meetings there plausibly, and candidates can't all go around all the prisons to see the prisoners. So it needs to be done largely by post, I guess. You imagine some more complex system of online debate. That would be very expensive to organise. I think plausibly it would be done primarily by electoral literature being mailed to prisoners. But they need to have a chance somehow to at least put questions to candidates, again, either by online or by mail, to engage somehow with them. And yeah, there are technologies we can use for that purpose.
Okay.
Yes, anything else?
That's fine, thank you.
Okay, thank you. I'd like to thank our guests. I think it's actually been one of the best rounds that we've had for a very long time in terms of giving us a range of views, but also in depth as well, actually. So I'd like to thank the guests for appearing, and we'll obviously keep you engaged with what we are doing going forward. And thank you all very much for attending. Thank you. So we're moving into private session. Can I ask members of the public if they would leave, please? Thank you.